Hello guys, this is Olayemi Diekolola Daniels, popularly known as Dieko Spectre, and welcome to another episode of Dieko Talks Law. On today's episode of Dieko Talks Law, we are talking about contract for the hire of a chattel. In my last class, we talked about collateral contract as an exception to the doctrine of privity of contract. And this is the fifth exception, the last class being the fourth exception. And we've talked about three other exceptions in relation to the doctrine of privity of contract. That is the exceptions to this doctrine. Now, before we go into the details of what we are talking about today, which are contract for the hire of a chattel as an exception to the doctrine of privity of contract, if this is your first time of coming to my channel, thank you so much for coming to my channel. Please don't forget to click the subscribe button. Don't forget to click the notification bell so that anytime I release a video of this nature, which is going to be of interest to you, you'll be one of the first set of people to watch that particular video. Also, don't forget to follow me on LinkedIn at Diekolola Daniels and on Instagram at Dieko_Daniels. Thank you so much as you do so. Let's go straight to the crux of our class for today. And what are we talking about? We are talking about contract for the hire of a chattel. Contract for the hire of a chattel. So let's go to our notes. In contract of hire of vessels and chattel, there is always an issue of what becomes of the subject matter of the charter party in the event that there is a change of ownership, i.e., where the owner of the vessel or chattel decides to sell the subject matter of the hire to another who is not or was not a party to the hire purchase agreement between the owner and the hirer. So now, I want you to look at this thing from two angles. I want to take you from land law, and I also want to take you from, ship and all that laws. So let's start with that of land law. Now, this is what we are talking about here. So now we have landlord of a house. Let's say like the one I used to use, landlord Taufik. Landlord Taufik has a tenant, and that is let's say tenant Sonwolu. The name of our tenant for today is Sonwolu. So landlord Taufik and tenant Sonwolu. Now tenant Sonwolu has told the landlord, landlord, I want to rent this house for 5 years straight. 5 years what? Straight. And then landlord Taufik says, okay, no problem. Per year is 1 million. 5 years, 5 million. Landlord Taufik said, is that fine by you? And then the tenant Sonwolu said, no problem, I'm fine with it. And then Sonwolu paid him how much? Paid him 5 million for the 5 years. And he was living on his property until Sonwolu had bah on his door. And Sonwolu was like, who is that? Who is that madman? Why are you knocking my door like that? And then he went outside and looked at the person. And then the person said, I am your landlord, and now I want to give you quick notice, leave this house. And this is just the third year. He still has about 2 more years to go. And in his head, he's like, what's going on here? When did all this rubbish start? I paid for this house and I paid for 5 years. This is what? The third year. I still have 2 more years to live in this house. And then the new landlord is now saying no. Let's say the landlord is landlord Ambode. And then landlord Ambode is saying no, you must leave this house. And then tenant Sonwolu is saying no, this house I paid for 5 years. Now, when you are going to apply the land law will tell you that when a person is about to purchase a land, a person has notice of whatever he finds on the land. And if he sees that somebody is on that land, he did not question the person before he buys the land and tell the landlord, hey, carry this person out or something. But he buys the land regardless of that person being on the land. What does the principle of landlord say? The principle of landlord says that he has notice of that person being on the land and therefore cannot chase that person from that land until when that person's time actually expires, because he is a bona fide purchaser for value, but with notice of Sonwolu's interest. Are you listening to me? He knew of Sonwolu's interest. He didn't ask questions about Sonwolu's interest. He saw Sonwolu on the land, but still he bought the land regardless. What does landlord say? Landlord say, nah, your business. You can't chase Sonwolu out of that place until Sonwolu is done. Now let us go to our ship and all that. So this ship rules is that, okay, you have a ship, right? For those who are in 2022, you know that Femi Otedola just rented a ship, right, for celebrating his 60 years birthday. He rented the ship for how many months? For 1 month. Good, fantastic. Now imagine that during the time that he rented that ship, so let us say that the second week, he rented it for 1 month, Abi. The second week, the owner of the ship then decided to what? To sell the ship to another person, and that other person now came to that ship and said, yes, Femi, I do not know you. You didn't pay money to me, and I am the new owner of this ship. So what I want you to do, you kindly get out of my ship. Now, the question is, at the point where the new ship owner does that, can Femi say, no, I have paid the old owner of this ship 2 billion naira, because he actually paid 2 billion naira. I have paid the owner of this ship, the former owner of the ship, 2 billion naira for 1 month, and until my 1 month elapses, I will not leave the ship. So when we get to the court, what is the rule? We already know the rule of landlord, right? So what does the court say about something like this? Now let us look at our first case of the Mattos versus Gibson. The Mattos versus Gibson, a 1859 case. Now, A chartered a ship to B, and during the currency of the charter party, you just like for landlord is rent. You know, when somebody comes to rent a house, you call it what? Rent or lease. But when it's a ship, you know, and somebody rent a ship, quote and unquote, it's called a charter party. So you don't say you rent a ship, you say you charter a ship, and the agreement, if it is landlord, is known as a rent agreement or a lease agreement, but in ship is known as a charter party agreement. So let us go back to what we are saying. So A chartered a ship to B, and during the currency of the charter party, A mortgaged the ship to C, who was aware, I like that, who was aware of the existence of the charter party. C, as mortgagee, threatened to sell the ship in total disregard of B's contractual rights. B applied for an interlocutory injunction to refrain C from doing so. What was the judgment of the court? On the application being refused by the court of first instance, B appealed. In allowing the appeal, Knight Bruce LJJ attempted to evolve a principle to govern all such situations. First, this is what Knight Bruce LJJ said. He said, reason and justice seem to describe that at least as a general rule, when a man by gift or purchase acquires property from another, look at it, with knowledge of a previous contract lawfully and for valuable consideration made by him with a third party to use and employ the property for a particular purpose in a specified manner, the acquirer shall not, to the material damage of the third party, in opposition to the contract and inconsistently with it, use and employ the property in a manner not allowable to the giver or the seller. The case was remitted back to Wood VC for trial. However, unfortunately, Wood VC ruled that on the fact before him, no injunction should be granted, and this was affirmed on appeal by Lord Chancellor Lord Kemford. It is noteworthy that despite the fact that the trial court and appellate court arrived at a different conclusion, the postulation offered by Knight LJJ still represents the law. So what are we saying in this instance? I love this part of what Knight Bruce LJJ said. He talked about knowledge. If you know that new buyer of the ship that Otedola chartered for 1 month, if that new buyer knew when he was buying it that Otedola had that ship for 1 month, that new buyer cannot chase Otedola out of it. That new buyer cannot use that ship inconsistent with Otedola's right during the currency of the charter party that Otedola had with the previous owner. Are you following my class? Do you understand? So far you had knowledge. Now when you are answering this question in exam, this is a locus classicus case on this issue of contract to hire a chattel. This is a locus classicus case, the Mattos versus Gibson. Very, very important for you to have in your head. Do you understand? Also, you must quote the judgment. Need not be word for word. You can just paraphrase. And what I would like to say, you can bring out the elements of it. And what are the elements? The very important element is knowledge. The second element is that there must be an existing charter party. The third element is that the sale must have changed hands between the person who the charter party was with and the other person. So the next question that you should ask is, how does this fall into the purview of privity of contract? It falls into that purview because Otedola can sue the new owner, not based on any contract that he had with the new owner, but based on the contract he had with the old owner. And say, my lord, there is an existing charter party with the old owner. Now the question is the new owner privy to that charter party? The answer is no. But because this is an exception to the principle or the doctrine of privity of contract, it then falls in, and the new owner will be said to be privy to that contract, since the new owner had knowledge of Otedola being on the ship and still decided to buy the ship. Then he cannot chase Otedola out of the ship during the currency of the charter party. So I have already mentioned what the three elements are for you. But let us go to our next case of Lord STRATHCONA Steamship Co. versus Dominion Coal Company. That's a 1926 case, a more recent case, and originated from Canada. Now the Lord Cousin Steamship Company chartered its ship, the Lord STRATHCONA, to the respondent for 10 years. Okay, that makes sense. With option for another 8 years at the end of the first period of that 10 years. Okay. Now, the owner of the ship changed hands on a number of occasions until he finally got to the appellants. They and all previous buyers were fully aware. I told you, just like I said in last time, the first question you need to ask, which is the reason why I brought the land law analogy, actual notice. Did you go to the land and you see the tenant on the land? Oh, you saw the tenant, but you decided to buy the house without asking questions. Or maybe you even asked questions and the tenant told you, I am here, and you still bought the land regardless. What does the law say? The law says that yes, you have that land, but you can only have the land subject to the tenant's rights. If the tenant is supposed to stay here for the next 10 years, you cannot chase that tenant until that next 10 years expires. Do you understand me? Because what you have noticed. And here, again in the fact, we have our first element. What is our first element? There must be notice. What does the fact say? They and all the previous buyers were aware of the charter party, and indeed by a memorandum of agreement made with the immediate previous owner of the ship, the appellant undertook to perform and accept all responsibility under the charter party. Contrary to this undertaking, they did not deliver the ship to the respondent for the continued performance of the charter party against the appellant. The appellant submitted that they were not bound either in law or in equity to respect the terms of the charter party. The judgment was that the respondent were granted injunction restraining the appellant from using the ship in any manner inconsistent with the charter party in the court of Nova Scotia, Canada. The Privy Council, in granting the injunction, relied on the judgment of Night Blues LJ in the Mattos versus Gibson. Now, can you see what I'm talking about? Even in this, our next case that we are talking about, we still brought what Knight Bruce said in the Mattos and Gibson. Can you see that you cannot run away from the Mattos and Gibson? It's a very important case. It's a locus classicus. And this other case also says the same thing. You have a currency of charter party, and then the ownership changed hands, and then this new person knew of the charter party and then want to ask inconsistent with that charter party. The court will tell you, no, you knew of the charter party, didn't you? The fact that you have changed hands and the fact that you are not a party to the initial contract which the person who has a charter party had with the owner of the ship. That's the previous owner. The fact that you're not a party to that contract does not mean that you cannot be sued based on the contract, most especially when you have notice of the contract, when you had knowledge of the contract. You cannot say, oh, I'm not a party, my lord, so to concern me. It concerns you. Do you understand that? And that is where we end our class for today. Thank you so much for watching to the end of the lecture. Please do not forget to share with your friends and colleagues and those people that you know are going to benefit greatly from this video. In our next class, we'll be talking about interference with contractual rights. Interference with what? With contractual rights. And that is going to be our sixth exception to the doctrine of privity of contract. Do not forget to follow me on LinkedIn at Daniels and on Instagram at Dearco_Daniels. I will see you in my next class.